tell the court that it wasn't dealing with secondary market transactions. Those were all situations where there was a relationship of privity between the investor and the promoter. It's a very...
All right, we're listening to the Coinbase versus the SEC court hearing where Coinbase is trying to convince the judge to dismiss the case based on prior case law, and they are not arguing facts that SEC has presented about staking and some wallets as being securities. They are arguing that it's their interpretation of whether these are investment contracts or not.
Requires the contracting parties to agree or scheme together that the contractee will invest in the contractor's profit-seeking endeavor. Now, that would probably be a point of disagreement between the way we're framing this matter and are litigating it to your honor, and the way we think it's going to be rightly decided in Judge Rakoff, but we can live with his formulation. And the reason is that the SEC in this case hasn't alleged anyone agreeing or scheming together to invest in the contractor's profit-seeking endeavor. The allegations here show no agreement of any kind as between these trades on the secondary market between strangers to invest in any contractor, that is to say promoter's business. And there's still less is there any kind of agreement that the buyer's payment would be invested in that business. So that's one point I really wanted to emphasize about Terraform. A second is moving to the summary judgment ruling. It's a very...
Here the judge asked Coinbase lawyer if he agreed with the prior judge's ruling about the Terraform case and how that may be similar to these allegations.
Contractor-contractee relationship, which I just said. And it also went out of its way to emphasize that there were ongoing relationships and obligations with respect to the token. So as to the UST token, which is the dollar denominated, the dollar pegged token, the court relied on the fact that the token could be deposited into the Anchor protocol and earn pro rata interest or dividends, thereby demonstrating that that investment was one that was in the ongoing enterprise. As to Luna, the court relied on the representations of the company that the token carried a claim to a distribution of transaction fees, again, proceeds coming from the enterprise to the investors in a relationship of privity. And similarly with the Mirror Protocol token, the court found that it earned fees from asset trades. And so we might have a lot to quarrel about with Judge Rakoff's decision, but the truth is we can live with its analysis because it recognized ultimately that there has to be a contractee-contractor relationship, and there has to be some ongoing engagement with the assets of the enterprise. Nothing like that's alleged in this case, Your Honor. So that is the way we're holding the Terraform case.
That was strong.
Yeah, that was a good rebuttal to them accepting the prior judge's rulings and saying that it is nothing like that is being alleged here.
And then it goes on to analyze whether the various transactions are investment contracts, and there, as here, the question whether a security existed was strictly a matter of an investment contract. And what it found, what the court found in Judge Torres' case, was that applying Howey to secondary market trades could not give rise to an investment contract. That was what Judge Torres found. And now, we don't think all of the same arguments were raised here as in that case, but the critical takeaway there is that Judge Torres recognized that secondary market token purchases of XRP were not investing in Ripple. And in that sense, it rejected what I think is a core portion of the Commission's argument before the court today, which is its investment in an ecosystem, at least with respect to transactions between strangers where no relationship exists, where no obligations travel. That couldn't be said there, and it can't be said here. Ripple couldn't make any promises to those people because it didn't even know who they were. Same here with each of the 12 tokens it issued. These are blind bid-ask trades, and therefore, as a matter of law, Judge Torres held, and we think correctly on this, investment contract law didn't apply. These trades couldn't be investment contracts and therefore couldn't be securities. And we think that branch of the whole thing, which was determinative in that case as to the trades that are issued here, secondary market trades, it's a very close cousin of the issue right before the court.
Well, yes, I understand that, and I think that's probably why the commission disagrees with it so much. The issue here, I'm not disagreeing with your recitation of it. I guess I'm not familiar with, in other aspects of securities laws, in other cases that I've had, where the primary-secondary market distinction holds so much force, and where the notion, or indeed the fact that it's blind bid, blind ask trades matters so much. Am I wrong, or are there other areas of the law where it really does, where it has similar import? Here, I just don't remember having to focus on this in other securities cases I've done.
Thank you for that question, Your Honor, which is it goes right to the heart of what's interesting about this. Because let's talk about stocks. Stock, they trade in blind bid ask all the time, and no one would think to say it's not a security. A stock reflects an interest in the permanent capital of a corporation. And when it trades, that interest in the permanent capital of the corporation, which is a participation in its capital structure, transfers in entirety from one holder to another holder. Attached to a stock are a bundle of rights: inspection rights, right to sue, right to dividends, right to dissolution, all that good stuff. They transfer in their entirety from one seller to the other seller. And therefore, in every case like that, the issue doesn't come up because it doesn't matter who holds it. They hold the same bundle of interests, the same claims against the same entity, insofar as they are just trading interests in permanent capital. Much the same can be said about what trade commonly as notes or bonds. Investment contracts are different because investment contracts are assets stapled to obligations. And the relevant question in every case is going to be whether with the asset travels the legal obligation. You don't need to ask that question in the context of a bond transaction, Your Honor. It does. You don't need to ask that question in the context of a stock transaction. It all travels. These are different, and that's why. And it just won't do, given the requirements of an investment contract, we don't think, to say that it's the same transaction on a secondary market as on a primary market, because whatever may have traveled with respect to the ICO is not likely to travel in a secondary offering. But what matters for our motion, Your Honor, is it's not alleged to have traveled. And no one can say that in the context of a bond or stock sale.
We've had thoughtful discussions for a while now on the idea about the need for a contractual relationship and an ongoing engagement with the assets of the enterprise. I think in another section of your briefing, a distinction that you draw or an argument that you make is that an investment contract must share the essential attributes of other securities. I assume that that's just a variation on the theme, and that what you're saying is, for example, that you have to have something more than ownership of the asset. Perhaps you have some interest in the enterprise, perhaps you have something else. But I do want to make sure, when you're talking about essential attributes, and that is your argument, is that something different than what we've been talking about? And if so, what are the essential attributes that you think I should be looking for here?
I think what I'd say in response to that question, Your Honor, is first of all, and when looked at the definitional provision of the 33 and the 34 Act, the 34 Act as is relevant, I guess, for the 12 that we're talking about now, there are a list of securities. Investment contract is one of a bunch. And each one of them is an instrument that carries the legal entitlement to the proceeds, assets, or profits of an ongoing business enterprise. And so part of our argument is that investment contract should be understood to be consistent with that recitation, and that is what, in the words of the statute, makes something commonly known as a security, as opposed to buying the output of what a company makes. It's the difference between investing in Beanie Baby Inc. and buying Beanie Babies. It's the difference between those two things. Additionally, we call attention to the Judge Posner's Walls decision, which I'm pretty confident.
That was a really good argument right now. He said that the law needs to distinguish that a contract is different between investing in Beanie Baby Inc. or investing in Beanie Babies themselves. He's saying the cryptocurrencies themselves are Beanie Babies, and you're not investing in the company that makes the Beanie Babies.
That is junior in the capital structure. And the things that are now being forced into the investment contract we think are different because they play no part in the capital structure and they carry no claims against the ongoing enterprise and carry no contractual rights at all.
Just one moment, please. Thank you.
This is a very interesting argument, by the way, this idea that a security has something additional rather than just holding the asset, that there's some kind of right that goes with it. That's very interesting. We're still on the line waiting for them to obviously talk here again. But
in the interest of transparency, as I was taking my notes over the weekend for this conference, I can't define when precisely I was typing this up. One of the issues that I had was that I believed it was difficult for you to argue, for Coinbase to argue, that a crypto asset purchaser has merely a hoped-for increase in the value of the asset itself. Because to me, that to the extent that the purchaser had a hope for an increase in the value, it was because of the efforts of the developer or the issuer. And I think what I'm understanding from our discussions this afternoon is that you're not disputing that as far as it goes, but for you, for your client, the issue is that there is missing, or at least missing allegations of some sort of way of enforcing that hoped-for increase in the value of the stock. And similarly, that there is no manner by which the purchaser remains engaged on an ongoing basis in the assets of the enterprise. Am I understanding that argument correctly?
I think that's fair, Your Honor. I think it's fair.
Or tell me that I'm overstating your hoped-for increase.
I don't think our argument, at least for purposes of this motion, is really fighting about whether someone's hoping for the increase. And we appreciate that the Commission has alleged that there were statements made that someone might have thought, if they were followed through upon, were going to lead to the increase. For purposes of today, we'll accept that. But it's not enough to make an investment contract. And it's not enough as a word of simple English when you think about investment contract, but it's not enough under the cases. It's not enough because, and here again, just to bang this drum, when you look at the real estate cases, you'll see they're very similar. And Judge Boudin has an analysis that says at some point, if the promises are enough and they seem enforceable enough, you might have an investment contract, and that's the holding of Duluth. There has to be something that is held out that's enforceable. That's what case after case after case says, and it's what's missing here. And it's really an important issue because there is no limiting principle of it applies. And that's because the vast majority of investments are going to be accompanied by someone saying something. But they aren't all securities. And the question is, what is and what isn't? You could have a situation where it isn't enough for the Commission to say, trust us, we're not going to use this authority except when it makes sense. Because that can lead to a company thinking it was complying with the securities laws and then being on the receiving end of an enforcement action. That's a familiar scenario for us. It could also lead to any number of businesses believing they're operating with, essentially in dealing with what are non-securities and finding out that they're not. Because every commodity has promotional statements around it, and they aren't all securities. And what makes it different is the contractual undertaking that gives an interest in the business. If you don't have that, you don't have a security. So I'm sorry for the long-winded answer. The short of it is you're right that we accept that there is an investment, and someone might think the promotional statements might, if acted upon, give rise to an increase. Our position is that's not enough, that the cases say it, and they say it over and over again.
Where is this in Howie? I mean, I understand from the securities law scholars that the precursors, the state law antecedents to Howie, speak about this, or at least they arose in that context. But the actual definition doesn't itself speak of this, either this contractual relationship or this obligation or means of enforcement or the ongoing engagement. So I don't know where it comes from, and I'd like to know where you're slotting it in the Howie test, if anywhere. And so let's start with that.
Yeah, well, it's a fair question. Howie only applies to instruments that constitute a contract, transaction, or scheme. And one answer to Your Honor's question is it's none of those things. It's not a contract. It's not a transaction. It's not a scheme. And we've talked about how it's not a contract, and we've shown, I think, that it's not a scheme as that phrase was understood in Howie. It is true that we have chosen in our presentation to the court to not reduce Howie to 3 elements and then ritualistically go through each of the 3 elements. And we did that for several reasons. One is that, as I mentioned earlier, there's a great deal of intersection between the issues. For example, the need for a contract came up in the context of a collateral agreement in REBAC in the discussion of the common enterprise, but it came up in the other circuit cases in the context of the reliance for profit solely on the work of others. So these issues cut through, but they do not appear all the time in the same place, but they appear over and over again in the Howie jurisprudence. When the Supreme Court talks about Howie, it doesn't reduce it to 3 elements. It looks at the instrument in front of it, and it tries to figure out whether it fits within the traditional definition of a security. A lot of the circuit court cases do the same thing the Walls case does, and Rodriguez. We would broadly say this, that much of what we say about the need for a contractual undertaking demonstrates the lack of any adequate pleading as to the generation of profits from the efforts of others, because those cases all say that has to be something that you can go and get. At least has to be promised to you that you can go and acquire that. So it fits in there. And much of what we say about the SEC's failure to allege an interest in an enterprise demonstrate a failure to plead a common enterprise within the Howie factors. And that's why we cite not just Howie over and over again, which we do, but the cases interpreting it.
Well, to that point, I had 2 reactions going in 2 different directions. And one was, I thought you were about to step in the trap that Mr. Costello laid for you earlier, where he discussed how Coinbase's citation to or use in any way of the Howie test undercut its major questions doctrines argument, because the idea of, by acknowledging Howie, you're as the playing field on which these issues are to be resolved, you're necessarily suggesting that there isn't some void, some almost ultra-virus activity that the commission is doing, which would implicate the major questions doctrine. So that's one thing to think about. Thing 2 is that I had a question to myself, which is to how your arguments applied, or was the logical extension of your arguments to be that there could be no common enterprise with respect to the 12 or 13 tokens. So we can save major questions for your colleague, who I know is going to speak to that, so she'll know to talk about that. But can you help me understand how, if at all, your arguments about the need for contractual or ongoing relationships, and I'm very much short-circuiting them by calling them just with those few words, I'm just sort of, evoking them for you, how that impacts the common enterprise analysis?
So we're listening to the live court hearing about Coinbase versus the SEC, and right now the judge noted that the Coinbase lawyer did not fall in the trap from the SEC of playing on the field of Howey test as the definitive test to decide this case. In fact, the lawyer just said Howey doesn't even apply here because none of these things are securities because there's no contracts. So let's listen to more.
Purchase agreement, and it provided for certainly a contractual undertaking, one in which there were going to be payments made in tokens for the performance of the enterprise or the return of the investment if the blockchain wasn't launched. And that seemed to be a very reasoned application of all of this in the Howey prompts. It fit in a way because you were able to look at the way the funds were invested and see them pooled in a common enterprise, and you were able to see the contractual undertaking that made for the return. Many of the cases, however, that are shoehorned into the complaint and might otherwise be litigated just can't fit. And one of the things that caused us to think a little differently about Howey, Your Honor, is that in this case is that it's a unique case, and I use that word advisedly, where the SEC alleges that an investment contract changes hands on a secondary market. That's new, and it fits very, very with real difficulty analytically with Howey, because Howey was a privity case, a primary issuance privity case. Nearly every single one of the cases that followed it was a primary issuer privity case. The only one that wasn't was maybe the Hawking case, which we've talked about in our briefs. I won't bore the court with, but it seemed in the context of a secondary transaction very difficult to shoehorn a blind transaction that required a contractual undertaking into the Howey analysis, which I do think fairly said wasn't built for that. But I want to be clear, we have no fear of Howey. It's a case that says an investment contract requires a contract. It actually says that the investment contract anticipates an investor taking shares in an enterprise, and it says repeatedly that those shares are to be evidenced by contracts and deeds, and those contracts and deeds should determine the future payout due investors. That was Howey, and that's our case.
Good counter argument. That was really good.
Speaking for a moment, going back to Terraform and also Judge Barbadoro's, I believe it's called Library, LBRY, at least that's what I was told at our last oral argument. I thought I understood, and at least it's been suggested to me, that I should understand those cases to stand for the propositions that what mattered for purposes of whether these were investment contracts or whether it's securities was whether the tokens were marketed as profitable investments and whether the profits were derived from the efforts of the issuer's management team. Now, neither of your issues, either an enforcement, a means of enforcement, or a sort of an ongoing interest or relationship is present. Has the argument that's been made to me, does it just overlook important things of Terraform? You've already talked about Terraform. Perhaps Library is the place to talk.
Well, I mean, I guess I do want to emphasize that Library, if that's how it's pronounced, is a pure ICO primary trading case, and that's a very important point of distinction. And because it was an ICO case, the matter of the contractual undertaking was much easier to resolve, and there were findings there about the way those proceeds were invested to launch the enterprise. On the subject of our slides, I'll just let the court draw the court's attention to slides 10 and 11, and we think this is really important because we don't think these cases, which had only to do with the ICO context, the initial offering context, the primary privity context, can be imported into the secondary arena. In the briefing, the Commission suggests that they stand for the proposition that primary and secondary transactions ought to be viewed in the same way. In every one of these cases, the Commission stood up and told the judge, we're not talking about secondary trades, they're different. Each one of them, including, as on the last slide here, 11, you can see that the judge even seemed quite frustrated about it every time he raised the matter of secondary transactions. We're not litigating that here. The Commission has to decide that, blah, blah, blah. And then the court said,
That's the official transcript, huh? Yeah, that's awesome.
right? Have I misunderstood your position? No. And so those cases, they're just not apposite here. They concern very different factual predicates.
Okay, thank you. I'd like to give you a break, please, if I could turn to your colleague, Mr. Schwartz, to talk about why my discussions with Mr. Margita about wallet and staking were all wrong. Thank you, sir.
Not all wrong, Your Honor.
Okay, great.
Your Honor, we'll start just by saying that there are actually I'll start with wallet if that's comfortable. There are actually very few allegations put at issue in the wallet claim. And as you heard from our friends at the front table, the law is well settled and the parties aren't disagreeing about what it is. We both cited the same 9 factors, and I think there's no real dispute that nearly all of them are absent from the SEC's allegations. They don't.
So it seems that Coinbase is not arguing facts. They're agreeing with all the facts. They're just arguing that SEC's interpretation of the law is wrong, and they're letting the judge decide whether she agrees that the law says these things are contracts or not, or if the SEC's interpretation is correct. So far, seems in favor of Coinbase, but let's wait and see.
You may find it helpful to look at page 15 in the deck. This just sets out on one slide for you, so you can see the 4 paragraphs in one place that the SEC points to as sufficient pleadings to survive the motion for judgment on the pleadings. We think these fail as a matter of law to support a claim that Wallet acts as a broker. I'll point you to 64 and 82 to start. Those together talk about Wallet routing customer orders through third-party decentralized exchanges. Assets from blockchain available to swap via Wallet, price comparisons across multiple exchanges. What you don't see in these allegations, Your Honor, are any well-pleaded facts showing that Wallet itself is doing any of these activities beyond allowing users access to the third-party platforms who give that functionality, who carry out those activities. And here, Your Honor asked about this earlier, and we want to direct your attention to it indeed. The user agreement, which is incorporated in the complaint by reference, lays this bare. The bottom line that it's not Wallet, but it's third-party platforms that are carrying out the very activities the SEC is referencing. And here, if you turn to slide 16, Your Honor, you'll see the portion of the Coinbase user agreement excerpted for you, setting forth what happens in Wallet. The app or browser provides a link to the platforms. Through the link, users, quote, navigate away from the Coinbase site to the DApp or the DEX. And, Your Honor put it very well in the Uniswap case. Once Wallet provides a technical connection to the third-party platforms, customers then direct the smart contracts on those platforms, like the Uniswap trading platform.
So this is same judge that ruled in favor of Uniswap when arguing similar findings. Uniswap is a decentralized exchange. So this judge is familiar with crypto and has already ruled in favor of decentralization and how that is not an issue when it comes to securities laws.
Base protocol that connects up to third-party platforms, that is not within Wallet. It's not alleged to be within Wallet, by the way. My colleagues at the front acknowledged that was noted in a footnote on page 27 of the brief. It was not alleged in the pleading. But I'll hasten to correct it anyway. 0x is one of those third-party platforms to which the Coinbase Wallet, the user interface, connects those users to do activities on a third-party platform. And that's a critical correction or clarification in light of the limits of the pleading and the user agreement that's fairly before the court. Another activity they point to in paragraph 75, you had a discussion about earlier, was solicitation of investors as something that was purportedly alleged. If you look back at paragraph 75 again on slide 15, the allegation is that Coinbase solicits customers by advertising features of Prime platform and wallet. Advertising to download the software. That's nothing like the findings that courts have made for solicitation of investors for particular investment transactions. That's the broker solicitation courts have addressed in the cases the SEC points you to. Hansen, Martino, in the SEC's brief, those cases are ones that identified as brokers agents of issuing companies who actively targeted prospective investors to raise capital by touting particular investments. None of that is alleged here. And so here again, I think it's fair to consider solely the limits of the allegation and the absence of well-pleaded facts, adding anything of this sort to solicitation of investors to conclude that this too is not alleged as one activity. Lastly, you had a discussion about paragraph 101, the last one listed on slide 15, that Coinbase used to charge customers transaction-based compensation for the activities on those third-party platforms. Coinbase no longer does charge for those activities, but even if it did, it's important to say the courts have been crystal clear, and it's long been true, commission-based payments standing alone do not make brokerage activities. And that's
okay,
not
but in fairness, they're not suggesting that the commission standing alone would have made Coinbase a broker. They are suggesting that what you say is providing access to third-party apps, DAPPS, and things like that. That's what I guess the concern I have.
Absolutely true. Yeah.
Right. So the concern I have is you all seem to have a dispute about the facts. I think I'm hearing you to tell me that I can resolve that dispute in this context because the user agreement and other statements, when compared with the paucity or the abstractness of the commission's allegations, no offense, is enough to allow me to find as you wish me to find. But I think they're saying, not yet, Fela, you've got to let this go through to discovery.
Yes, Your Honor.
Okay.
I think that's exactly right. With respect to the allegations in 64 and 82 that we talked about, that paucity, saying that while it does something through third-party platforms, that something happens via wallet, that the price compare happens on us, each of those is the circumstance you just described, where the paucity plus the user agreement gives you ample basis to decide the pleadings don't suffice. But where I'll round out the picture is with respect to the solicitation of investors, the only other core broker activity the SEC claims to have even alleged, that on its face does not allege what is understood as a matter of law to be the solicitation of investors by brokers.
I see. I appreciate the clarification. Thank you. Let me just take a note of that.
This isn't looking good for the SEC so far. Full summary, obviously, over at ehack.com. We're waiting for the judge here to keep talking and ask our next question of Coinbase, then we'll get to summary arguments.
Your Honor, in case useful, it occurs to me from your discussion, one way that the SEC has sought to suggest there's an alternative frame or some different version of facts is by saying the user interface connects and therefore facilitates, it puts these parties together. Again, this is not a fact dispute. As a matter of law, that facilitation or putting parties together does not make brokerage activity. And I'll point Your Honor's attention to a case in our briefing, the Reed case. This is also found in the Foundation Ventures case. But Judge Lyman in the Reed case made clear merely providing information or bringing two parties together to make their own contract does not transform an individual or entity into a broker, even if they receive commission-based payments. At most, it's the activities of a finder, and that is not subject to the securities laws. In that case, the person at issue didn't negotiate the transactions, didn't engage in substantive conversations, give valuation advice, the variety of core activities I mentioned that aren't even purported to be alleged here. And so,
fair enough, sir, but I think the concern of the commission, and it might be a concern that I share, is to the extent that what we're talking about is how you can implement technology to make things faster, easier, have access to even more entities. There's a concern I believe the commission has that it can't just be that technology obviates a finding that one is a broker, because if what you do, if you do broker-y functions, but you do them through some sort of automated mechanism that you have at your disposal, you might still be a broker. I think that's what the commission is saying. I think what you're saying, and let me just confirm that, is that the allegations that are contained in the pleadings as amplified or perhaps given further detail by the user agreement are just not enough. Am I understanding your argument correctly?
I think that's exactly right with respect to those activities that the commission claims to have alleged.
Okay.
And there's no dispute about the variety of core activities they don't claim to have alleged that I mentioned at the outset.
Right. So there are a number of factors that I may consider in determining whether someone is acting as a broker. You're saying they don't allege all 9 or whatever; they allege a couple, and as to those, there are reasons to disbelieve or to view with skepticism the allegations that are made.
Yes, we would say there's reason to find they're not well-pleaded facts to support those allegations.
Or that. Okay. Thank you. Shall we then speak of staking, sir?
Yes, absolutely.
Are there slides about staking?
You better believe it, Judge.
Okay.
I will turn your attention. In fact, I hope it's helpful. Slide 17 was designed late at night, bearing in mind and reflecting on the last time we all gathered. And so I'm very glad to give it some attention. Your Honor asked a question, about what's properly before you when it comes to staking back in July. And that's why we thought it might be worth stepping back to frame what is properly at issue in the pleadings when it comes to the staking product. And to be clear, we think there are 3 different reasons, each sufficient on its own for this claim to be dismissed. But I'm going to start with the investment of money. And let me frame this for you. We've set out here the various provisions from the allegations in the complaint and from the user agreement, which we think suffice to give you the picture of the facts that are relevant for disposing of these pleadings. At the foundation of the blockchains is the need to validate each new block or transaction that's added before it's added to ensure the security and accuracy on a consensus basis. You can see that in paragraph 312. Where staking comes in, Your Honor, is from 2 propositions, again, set out in the sources before you. Number 1, blockchains that use proof of stake to achieve the consensus I mentioned set a fee, they call it rewards, that they pay to token holders to perform this critical validation service. That's set out in paragraphs 312 and 313 of the complaint. Number 2, the users who take on this validation service to put up or stake some of their tokens while they're performing the validation service they get paid for. Paragraph 313 calls these staked assets collateral against improper validation, and collateral that's held in the protocol while the services are being carried out. For token holders who stake on their own, Your Honor, that's it. It's a fee for validation service for the blockchain, and you can identify that, again, in the allegations before you, confirmed by the provisions of the user agreement. Some users then choose to subcontract that service to Coinbase. They hire Coinbase to operate the IT to validate on their behalf, and they direct Coinbase to stake their tokens on the blockchain while that happens. Those are the facts from the complaint and the user agreement. And with these in hand, we think you can turn to each of the 2 reasons. We'll start with the investment of money, of why the complaint fails to plead an investment of money under Howey. And I'll begin, Your Honor, just with a case that the SEC emphasized to you, the Rivera case from the 9th Circuit. The Court of Appeals there said one has to, quote, commit assets to the enterprise in such a manner as to face the risk of loss. And I want to focus on the first part of that. Commit assets to the enterprise to have an investment of money. Sounds straightforward. Without a contribution of assets to the capital structure, there's just no investment. Here, the SEC has made no allegation. There's no plausible claims that they could, that staking customers commit anything to Coinbase in this way. They just direct Coinbase in the normal custodial relationship to make their tokens available to the blockchain as collateral, paragraph 313 puts it, for potential slashing for error validation, and to provide IT services in connection with it. Now, the sole way that the SEC tries to satisfy this commitment of assets requirement, I'll point you to slide 18 for this, just to put their allegation in front of you. Paragraphs 340 and 341 and repeated elsewhere, is to tell you staking customers tender and just give up control over their tokens to Coinbase. And, here going to your question earlier about, where something is wrong but properly before you to resolve, center stage, Your Honor, this bare allegation warrants no credit and it's contradicted by the user agreement. You can see on the next slide, slide 19, section 2.7.3 of the user agreement and the appendix, which establish you, the customer, control the digital assets held in your digital wallet and Appendix 4 extends this to staking services, whether or not the digital asset is staked. And this is important, in granting a motion to dismiss the Underwood complaint against Coinbase, Judge Engelmeyer addressed the same user agreement. And much as Your Honor described earlier, said where a document is incorporated by reference, the court need not accept contrary allegations in the complaint that seek to elude the facts contained in the incorporated document. His words were, the user agreement checkmated those plaintiffs from adequately pleading their claims. And, Your Honor, you won't be surprised to hear, we think you should likewise find the SEC's bare allegations that customers give up control over staked tokens in order to claim there's a commitment of assets. It's checkmated by the user agreement. And taking that aside, there are no well-pleaded facts suggesting that anything about this relationship, this fee-for-service relationship that users have with the blockchain and they subcontract to Coinbase, there is no commitment of assets. There is no contribution of capital by the users to Coinbase's capital structure that could possibly satisfy the investment of money requirement that Rivera and courts have long required. Another aspect of staking you asked about, Your Honor, unless there's a further question about that, is risk. We spent some time in colloquy about risk. And that goes to the second half of the sentence from Rivera, again, that the SEC is trying to rely on.
Well, are you suggesting that it's wrong for them to rely on it?
No, I think it's the right case to rely on. It just doesn't help them. Unfortunately, their allegations fall short of that standard of law. And here again, I'll just quote you the back half of what we said. An investor must commit his assets to the enterprise in such a manner as to subject himself to financial loss. And it's not just the Ninth Circuit. The Second Circuit has affirmed that the Supreme Court added this limiting requirement as well. Now, on slide 20, Your Honor, you'll see the handful of paragraphs that the SEC tells you suffice to allege risk of loss from staking. And I'm happy to take you through them. I'll tell you, broadly speaking, apart from the conclusory allegation at the top, the first two, 341 and 343, concern blockchain requirements for staking and validation. The bottom two don't concern staking. They're just risks that are general to token holders. Both buckets of these allegations fail as a matter of law to assert risk of financial loss in the commitment of assets to the Coinbase enterprise.
Let me ask you to pause for a minute, sir. I've spoiled myself a little bit by looking at the next slide, it's slide 21, which speaks about the risk of loss and how it's discussed in the user agreement. My reaction to reading the briefing was that I thought that Coinbase argued in a number of ways that the risk of loss was infinitesimal, or that the risk of loss was something that could be addressed or made up for by Coinbase if anybody lost money, or that the risk of loss was the same if you were self-staking, or that the risk of loss was something that you'd have just as a customer of Coinbase, irrespective of whether you staked or not. But all of those arguments, they sounded to me a little bit defensive because they all seemed to presuppose that there was a possibility of loss. If the Ninth Circuit test that we're saying is the right test to use is that the risk of loss is itself enough, then the fact that the risk of loss is really small, could be made up, or it could happen in other circumstances, I'm not sure it gives me a complete answer. Can you help with that?
Thank you for the question. It covers the waterfront really well, and so let me try to take it in a few pieces if I can.
So here they're discussing staking and whether that's a contract. And I think the main argument that the lawyer for Coinbase is using is that the user agreement, and this was upheld by another judge in a different case, clearly says that Coinbase doesn't take control of the funds, and those funds do not help capital structure of Coinbase. They're always at disposal of the user, and the user directs Coinbase as a contractor to stake and validate the blockchain on their behalf to entitle them to rewards from the blockchain. A user could do this themselves, but they're just contracting Coinbase, and their funds are always still theirs. So they're never giving up anything to Coinbase.
Paragraph 333 of the complaint acknowledges Coinbase does no staking business. So that quote has nothing to do with staking. So there's a discussion about slashing risk. Coinbase indemnifies for it. The allegation acknowledges that risk does not exist. The second risk that's talked about in 341 is a risk of loss while staked because tokens can't be used for other purposes like trading or transferring. And here again, this is just restating a condition imposed by the blockchain that the validators who choose to sign up for this service and perform this service for the blockchain in return for a fee put up collateral while they're doing the service. Think of it something like a security deposit. They're not going to do a bad job. They're not going to make mistakes while they're there. They get it back at the end. There's the allegation of risk that they can't do other things with their collateral, their security deposit, doesn't state a risk of financial loss that Mubera was talking about in such a manner from your investment. The last two, again, I think Your Honor summarized it very well. 344 and 345 are just not staking risks. They're risks alleged for anyone who holds tokens. Now, the way the SEC frames that as a defensible and sufficient allegation is to say that there's a risk of ownership loss for all
Yes,
tokens.
this is live
and they
right now.
don't have to allege more. And I want to tell you why that's wrong, Your Honor. But first, as you saw in the briefing, we do take issue with and dispute that standard of law. That's exactly what courts have to show is that investors put capital into a business with the risk that its performance may lead to their inability to recover the capital. That's what investing in such a manner to face the risk of loss is, according to Rubera. And, stepping back, here the SEC is charging Coinbase with offering an investment contract through its staking service. To have an investment of money that's required for that, there has to be a risk of loss alleged that arises from staking through Coinbase. But even if that's not necessary, and Your Honor says, well, what about their risk of ownership loss? You can see on the slide, as you jumped ahead to slide 21, there are no well-pleaded facts here stating a risk of ownership loss over stake tokens. My friends at the front table say that's our say-so. If the courts say so over and over again, for a custodial validator like Coinbase, ownership over staked assets is dictated by the contractual agreement between the user and the custodian. You can see in these provisions we've set out for you, Your Honor, this user agreement is crystal clear. Title to staked assets at all times remain with the users. They do not transfer to Coinbase. They don't become property of Coinbase, and they don't become subject to general creditors' claims under any circumstances. And these guarantees are obviously very important.
This is huge. The fact that they're clarifying that the user agreement states that all the staked Ethereum, for example, is always property of the users and never of Coinbase. In case Coinbase goes bankrupt, creditors never have rights to that because that doesn't belong to Coinbase, that belongs to users.
Agreement, finding, quote.
So there is no potential of a loss of their funds.
Title to the digital assets. Appendix 4 says the same thing for staking services. They do not affect ownership. Taking that on its face, Your Honor, this is an independent reason why, as a matter of law, the complaint fails to plead the required investment of money bearing the risk of financial loss, and the claim should be dismissed. We think that does resolve the staking claim.
Well, you're saying it's an independent reason, and that's because the first reason is because these aren't securities.
Well, the first reason is there's no investment of money in the capital structure.
Okay.
And second, in any case, there's no risk of financial loss well pleaded in the allegations. The last aspect of staking, I'm happy to, Your Honor, if you'd like to discuss it, although mindful of time, I'll respect if you've heard enough about staking for the day, is the efforts of others that you had some colloquy with our friends from the front table as well.
A little bit of the efforts of others, I guess it seems that there's not necessarily a disagreement between what activities or what services Coinbase is or is not affording to these to folks involved in the staking process, but whether those amount to ministerial or managerial.
For the most part, I think that's right. I'll offer one clarification. You can see on slide 22, we tried to group the various activities from Coinbase that the SEC alleges as efforts of others. The reason I offer an asterisk to that, otherwise apt description, Your Honor, is the first few categories do not concern Coinbase's activities or those that are alleged to be managerial. The first category, the group of paragraphs, concern general proof-of-stake activities, not about Coinbase, and so it's not about Coinbase's efforts.
Fair.
The second is about retaining third parties to stake assets. Again, not about Coinbase, not Coinbase's efforts. The third category is about liquidity pools for quicker withdrawal. Something that's acknowledged in the complaint is no longer the case in Coinbase staking, but in any event, again, on its face, addresses the administrative convenience of unstaking, of exiting the staking program. It doesn't offer posit any managerial qualities or otherwise in the conduct of the actual staking program at issue. So those first three, I'll just say, are actually separate. The bottom two are, the remaining efforts the SEC alleges, and quite as Your Honor put it, those just aren't the type of aren't the type of managerial and entrepreneurial efforts required by Howey. They are just the type of clerical and routine functions that courts have found do not suffice to plead the requisite standard, the material, significant impact on returns. That goes for the IT services with software and equipment. That goes for the pooling, where there's an aggregation of tokens to stake. And, we direct Your Honor's attention to the Life Partners case, where what was found to be ministerial, Your Honor, was an almost identical constellation of efforts that was found to have, quote, no material impact on the profits of the investors, including because these were services that, quote, anyone, including the supposed investor himself, could supply these services. And there were a number of others who could have as well. So, again, happy to delve into it further, but we would commend those excerpts from that we put in front of Your Honor from Life Partners to lay bare quite how clear it is as a matter of law that we think the back office, mechanical, outsourced IT services and administration that's alleged in those bottom two categories of paragraphs do not rise to the level of an adequate pleading of efforts of others.
Thank you so much. I think that leaves me with Ms. Eddy and the major questions doctrine. One of the discussions I was having with your colleague, Mr. Sabat, was the reconciliation, if there needs to be one, between Coinbase's arguments about the applicability or how it interprets the Howey test and how that works with the arguments it's making about the major questions doctrine. So perhaps we could begin there. Could you help me reconcile those two ideas? And what I mean in particular is, to the extent that you are arguing that the Howey test applies by its terms, that that's the test I should be using and that we should be working in that framework rather than suggesting that these particular tokens are outside of that framework, does that in any way exist in tension with your argument that the SEC's bringing up this case amounts to some sort of arrogation of powers it doesn't have? And I'll ask you, just because I know this court, to grab the microphone and bring it near you. I'm sure we will hear you, but I just know that there's something about those microphones. Thank you so much.
Thank you, Your Honor. And I will say, I'll preface this by saying our position is that our interpretation of Howey and our argument about the investment contract and what it requires fortifies the major questions position that we have. In fact, it undergirds the whole thing. We don't think you even get to major questions here because the text and the context and the precedent establish that the position the SEC is advancing here is not grounded in law. But if the court were to disagree and to find plausibility in the SEC's position, that's when the major questions doctrine would kick in, and it would compel rejection of that position. And that's because, as Mr. Sabat, I think, already explained at length, the transactions on Coinbase's secondary exchange are of a different character than anything that the SEC has asserted regulatory authority over before. And they are of a different character than the interpretation the SEC itself has advanced in Howey, in its briefing there. It talked about contractual arrangements, for example. It's different than any position that it's taken in briefing since, in some of the briefs that Mr. Sabat highlighted from Edwards. it's taking a different position than Chair Gensler took in 2021 when he appeared before Congress and asked for regulatory authority to cover transactions on crypto exchanges.
Let me pause you right there for a moment, because I want to know the degree to which you're asking me to look at certain allegations in the preface to your answer that, again, to me seem to speak more of a question of optics or not. For example, I can understand Coinbase's frustration that it tried to be helpful. I mean, if that's how it perceives what it was doing. It tried to be helpful. It tried to talk to the commission. It tried to get some guidance. And then, rats, there's an enforcement action brought against it. So I get that. For me, there's a layer of, again, optics that I'm really not considering, or at least I didn't think I need to be considering in the context of the major questions doctrine. The fact that you asked for guidance, your client asked for guidance and didn't get it, to me doesn't suggest major questions doctrine. I'm assuming instead I'm looking at a narrower universe of materials, which would be the statements of SEC officials, the higher-ups there, and the positions that the commission itself has taken in other cases. Am I correct, or am I also supposed to be looking at everybody's efforts to be helpful?
Your Honor, you're absolutely correct.
Okay.
There is a good portion of the allegations in the preface to our answer that you can properly consider and should consider, not just as optics, but as factors, as going to factors that the Supreme Court has repeatedly identified as relevant. The bevy of congressional activity surrounding this very significant question of how to regulate crypto, and the fact that Chair Gensler made those statements to Congress in 2021. All those facts you can consider and should consider, we submit. And I don't think the SEC disputes that. Those aren't really facts.
No, I don't think they dispute it. I think what they say is that the Gensler statement's taken out of context, and you disagree. There's quite detailed and yet not not the same results. Everybody has a view of that, and I understand that. With respect to the bevy of congressional activity, I thought I understood the argument to be, and it's also presented in some of the amicus briefs, is that the fact that that Congress seeks greater clarity doesn't necessarily mean that the SEC lacks the authority in this space. I appreciate that your view is it does, but I think their argument is we've always had rights to regulate securities, and it may have took us a moment. We may have had stumbled along the way, but we figured out how we could do it, and here we are doing it. As distinguished, I'm not sure it's of a piece, for example, with, just to pull something out of the air, like the OSHA vaccine mandate. Whatever your position is on that, I'm not sure that was something that OSHA did on a regular basis. Or the student debt cancellation, I'm not sure that's something done on a regular basis. Here, the commission would argue, this is what we do. And yes, the token, the asset may be different, because over time, different assets develop, but it's really no different in terms of the mode of analysis that we're applying. Why are they wrong? What is it about crypto that makes it so qualitatively different than the other assets or the other putative securities that the commission has considered and regulated over time?
Let me begin by saying that it's not what makes crypto special. It's the nature of the transaction that the SEC is now designating and calling a security, that it didn't designate or recognize as a security in any of its prior briefing over sort of the 90-year history of the Exchange Act, in Chair Gensler's comments to Congress. And this is a special kind of transaction. It's one that doesn't have an ongoing legal relationship between the issuer and the purchaser. So that is the class of transaction that is at issue here, and the SEC is offering an interpretation through a campaign of enforcement actions that is not just arrogating authority to itself, it is expanding its jurisdictional perimeter. That is, in some sense, it's similar to the Brown and Williamson case, where there was the question was tobacco a drug or device? Here the question is this class of transaction a security? And that, the congressional activity is, we're not saying that's dispositive, but it is something the court can and should consider under the governing precedents in assessing whether Congress has spoken clearly about whether the term security, the term investment contract, can properly be conceived to cover what the SEC is identifying and pursuing here. And I think for all the reasons that Mr. Sabat already gave, there's no clear statement of that kind here.
I just want to make sure I understand what you're saying, because it was not the answer I was expecting, which doesn't mean it wasn't a perfectly fine answer. You're saying that what is the thing I should be concerned about is not crypto assets. What are they? Are they securities or are they not? But that the particular transaction that's being challenged, the particular types of transactions that are being challenged, are so different than anything as to which the Commission's asserted authority in its history. Am I understanding that correctly?
That is the first part, Your Honor.
Okay,
yes,
that's fine. I will
set the court. And I think that the cases look both at what is the nature of the arrogation of authority, how expansive it is it? And I think that's part one of the answer. The cases also look at what is the impact here, and what is the significance on the practical level of the expansion that the agency is asserting. And that's where we look at the fact that this is an arrogation of authority over an entire industry. And
but I'm sorry, the impact, I'm looking at the impact on whom? On both the industry and on...
So it seems like Coinbase is arguing that SEC hasn't had the authority to do this and it's impacted the entire industry.
Something in the tens to something in the thousands or something like that. So am I looking at what this could do in terms of how much it would expand the number of enforcement actions the Commission could bring, or am I looking at it in terms of the crypto industry itself?
You're looking at it, Your Honor, I think in both, but it's certainly the latter.
Okay.
And the Commission does try to advance this argument that this is really just routine enforcement action and sort of incremental routine enforcement action. It is certainly true that the complaint here leaves allegations regarding just 12 tokens traded on Coinbase. But it is part of a concerted campaign against crypto exchanges generally. There were other lawsuits filed in close proximity to this one against other crypto exchanges. And it is obvious that if the court were to accept the Commission's definition of investment contract in this case, that would have essentially legislative implications. It would affect the whole industry. And the Commission has kind of made no apologies for this.
Please pause for a second. Two follow-up questions before you move to your next section of argument. I think you're suggesting to me that I need to look at this.
So here's the 12 securities that, or 12 tokens that are in question. I'll cover this in my summary video. Solana, Cardano, Matic, File, Sand, Axis, CHZ, Flow, ICP, Near, VGX, Dash, and XO. So these are the tokens that Coinbase alleges were securities.
It is not just a matter of enforcement. I want to be clear about that too. If the court were to take the SEC's view that the token transaction, the trades over Coinbase's secondary exchange are investment contracts, then the implications of that are that the SEC's regulatory apparatus applies to crypto exchanges. The court can and should take that into account. And I know there's been some suggestion that there's an absence of authority for the proposition that an enforcement action can give rise to the major questions doctrine. And I want to just point the court, one of the amici cites this, but it's the Gonzalez case, in which an enforcement policy was at issue. And the major questions doctrine was applied there. Attorney General Ashcroft had issued an interpretive rule construing the Controlled Substances Act to prohibit physician-assisted suicide. And the court held that wasn't a regulation. It wasn't entitled to any deference of any kind. It was an announcement of an enforcement policy, and it applied the major questions doctrine to that. And I think the doctrine applies when the position that the agency is advancing is essentially an encroachment upon Congress's prerogative. That is what's going on here. Congress, 1934, listed out the instruments that qualify as securities. Investment contract is one of them. The SEC has been litigating the contours of investment contract for decades, never advancing the theory it is now advancing in this case. And that's precisely the sort of circumstance in which the major questions doctrine should be invoked and should be applied.
Okay.
The second argument you make is that accepting their position would have effectively legislative implications. Did I understand that argument correctly?
Yes, I think that's right, Your Honor. The Commission deliberately, being that Congress has not acted, has not granted the authority to regulate crypto, has instead taken matters into its own hands. It has gone back and looked into the Act from 1934 and said, aha, we have the authority we asked for 2 years ago. That's impermissible. And it's impermissible because there's no clear statement that this kind of transaction fits within the definition of a security, and thus within the Commission's own jurisdiction.
I guess what concerns me is I'm reluctant to focus to view through too narrow a lens what the Commission's enforcement ability is. I think they're telling me it is routine, and you're saying it's not. So I appreciate that. I'm just saying that. I guess another issue is 10 years on the bench, no one has ever said to me major questions doctrine until this case. I understand 10 years is, just a very small drop in the bucket to many judges, but I'm sort of shocked. I've had some interesting cases, and this has never come up. My read or my research into this area does not suggest that it comes up very often, and even less often does it actually get found by a court. So I'm not, I guess my question, and I mean no disrespect to your clients, but I'm just not sure the crypto industry that it is so major or so extraordinary that I need to find it here. I understand your initial point, which is, well, you don't have to if you just go our way on the other arguments. Yeah, I get that. But I'm saying I have a natural hesitation to involve or to make a finding that something implicates the major questions doctrine because it is so infrequently done. And I'm not sure this is on a par with the student loan forgiveness or with the energy industry. And I know what Brown and Williamson is. Perhaps I might have my own skepticism about the Brown and Williamson decision. I appreciate, of course, that I'm bound by it. But I guess I'd like a little bit of comfort that what you're asking me to do is, here's the tension. You're saying to me, what the Commission is doing is so crazy, so beyond what it should be doing, that you need to stop them. My point to you is, it is so infrequently that, and in fact, this is the one case where I've been asked to do that I worry that I am, in my own lane, doing exactly the thing that you're arguing the Commission is doing here, which is to take power I don't have, to stop activity I shouldn't be stopping. So that's why I'm asking. I mean, I'm not asking you to hold my hand here, but I'm just saying there's a comfort that I need to have that this isn't as much of a nuclear option as I think it is based on the cases that I've read.
Your Honor, you spoke about your own power and the concern about stepping outside your lane. And I want to just return to a comment that you made when speaking to my colleagues on the front table about Senator Loomis's brief.
Yes.
The question here is, as between Congress and the SEC, who has the power to legislate this question? And that's I think the question that that is central to your inquiry. I do want to note, though, and just make sure the court has in mind, there are a wide variety of circumstances in which the major questions doctrine has been invoked and has been applied. And just
Yes, they're two different things, right? Being invoked and being applied. So go ahead.
well, let's talk about, I guess, the ones in which it's been applied. It's been applied to the elimination of rate publication requirements for 40% of telecom providers in the long-distance business. That's the MCI case. It's been applied to new emissions controls for existing coal mines. So that's West Virginia. It's been applied, the eviction moratorium at issue in the Alabama Association of Realtors case was one affecting 6 to 17 million tenants with a potential economic impact of $50 billion. And let me just pause on that for a moment because there's been some math thrown around.
There's a lot of math.
There's a lot of math. This is not a math question.
Yes.
And none of the cases treat this as a math question or as a question of fixed numbers. It gives a flavor of the significance of the agency's, the impact of the agency's action. Chair Gensler himself, the very day he made the request of Congress for authority to assert regulatory authority over crypto exchanges, prefaced his comment by saying this is a $2 trillion industry. The FCC's complaint, I think paragraph 1, talks about billions of dollars in trades happening every day. The economic impact here could be really crippling. And I want to just make a point that hasn't gotten a lot of play here today yet, which is the architecture that the SEC has in place it does not work with crypto. That's why my clients made a pitch for rulemaking. There is no pathway to registration as it stands right now. So if the SEC's position is accepted, the potential impact of that is potentially crippling. On the other hand, if the SEC...
Is it crippling, or are you about to tell me it's existential? Or is it existential for those assets as to which transactions in the assets, however they come about, are investment contracts?
I think it is certainly, the impact is vast, Your Honor, and I will return again to the point that the SEC is offering no limiting principle, really, to what it will designate as an investment.
I think the Coinbase lawyer is kind of putting her foot in her mouth at this point. She could do a little better here.
It could go, I suppose, a different way. The SEC could put in place an entire new architecture that would address this. That's the kind of change, though, that the major questions doctrine says should not be effectuated by the agency. That's something that Congress should decide. Those are the kinds of questions that Congress has before it now, and that Congress should have been left to decide, and before the SEC came and took matters in its own hands.
But in fairness, they haven't done anything. So I am a little bit concerned. I have a concern about not recognizing someone's authority to do something in this space. The answer may be that I'm just out of luck until Congress acts. as you would say, Chair Gensler recognized some time ago. But all right, maybe I'll just leave it at that. Okay, thank you. Did I just deprive you of some great thought you wanted me to know about?
Don't believe so, Your Honor, but I'm sure there will be an opportunity later if something comes to mind that I think I missed.
Funny you should mention that. We've now finished our 4th hour of argument, and I congratulate those of you who've stayed and listened through all of this. I have asked the 14 pages of questions I wanted to ask, and I thank you very much. And I
Summary arguments coming up.
I imagine that if I asked you, you would not forego the opportunity to say something to me in the vein of a summation, or something I didn't know, something I need to focus on, or something I was too dumb to ask you about. So we're going to take another break, and I'm going to ask folks to get together. Mr. Pekin, my thought was that's where you would be coming in and you'd be speaking to that issue. But if there's something else, then tell me now, because you were designated cleanup. So what is it
I was responsible for correcting errors. Since none were made, there was nothing for me to contribute.
I do appreciate the love, the back to the house for each other. I still think you should make a play to speak, but that's just me.
So, Your Honor, this is the longest I've been silent for in my entire life.
I'm not going to disagree. Yeah. Okay, so take 10 minutes, think small thoughts, just something really summary that you want me to know that I'm not going to get from our argument, which I promise you I will reread the transcript of, and from the briefing. And just in case there's something we didn't cover and we should have, that's your opportunity. It should not, let's say 5-10 minutes maximum. This is not, the 2-hour summation at a trial. But take the break. Thank you all very, very much for your preparation. And my thanks to both to those of you who've spoken today.
Okay, so they're going to take a 10-minute break and come back with 5-minute summary arguments that hopefully will wrap it all up. The judge did ask them to include in their arguments stuff that she was, quote, too dumb to ask. She's being really kind to both parties, I think, and seems very reasonable and curious. So hopefully they will come back and wrap this up. I could imagine it being... I don't think she'll throw it out today. Sounds like she will do a summary argument, hear them out, reread the transcripts, think about it, maybe ask them follow-up questions on another day, but could make a decision later this week or in a couple of weeks, or it could be after another day or two of talking, if it's straightforward. So... let's see what our friend Kevin thinks about this.
The SEC is losing this one. I actually wrote on ehack.com, quote, "The SEC needs a better link between investing in a token and the expectation of profit in a project, in developers, etc. If the SEC can link that the benefits of development move with the asset, the SEC will have a stronger case." So, if I'm the SEC right now, okay, I'm sitting back there, I'm reading ehack.com, and I'm going, shit, we got a problem, okay? So okay, if I'm the SEC, I'm going, all right, the strongest argument that we can make to argue that tokens are a security is that people invest in the tokens to invest in the common enterprise of other individuals. Developers, the metaverse, apps, whatever it is. And because people are investing their money into that, and the representation of that investment via a token flows through the entire economy, the ecosystem, whatever it is, because the tokens are fungible, essentially. It's exactly the same, but you have sort of your share of ownership. Then you could argue that as the developers do a better job, the token goes up in value, and therefore you're benefiting from the profits of others. I think the SEC needs to make a very clear argument and go, in my opinion, all they have to say is, look, a stock, like if there are 100 shares in a company and a company and somebody has one share of those 100 shares in a company, they own 1% of the company. So they get 1% of the profits. Well, how is that similar to a token? Well, with a token or whatever, you have 1 out of 100 shares. Maybe you have voting rights because of that. Maybe if you get to 2/3, you could take control of the whole enterprise, kind of like a hostile takeover, right? Those are the comparisons that I would be making if I'm the SEC, okay? So if I wanted to be the SEC, I would make very, very clear comparisons between how a token is just a slice of the ecosystem, and therefore anybody who holds that slice is a beneficiary of that slice. If they get enough slices, they have control. Okay, that's an argument. I'm not saying that's the best argument. I'm just saying that would be an argument. Okay, so then if you're Coinbase, honestly, you don't have to say much more, okay? Like, Coinbase is winning. Coinbase is absolutely crushing it here. Mostly because, quite frankly, well, some of the attorneys have done really good at Coinbase. The first attorney wasn't the best. The judge was basically handing Coinbase arguments. The judge is basically like, hey, there's no contract here, right? And if there's no contract, it can't be a security, right? And if there's no contract, then somebody can't sue for fraud. If, let's say, Solana goes bankrupt, can somebody sue for fraud? Now, Coinbase screwed up at one point. Coinbase is like, yeah. If the project goes bankrupt, then they can sue. And the judge is like, bro, I just fed you an argument, and you just flipped it on me. What basis would they have to sue? Is there a contract? You're right, Your Honor. There's no contract, so I guess I would have no basis to sue. And the judge is kind of like, that's what I thought. So the judge here was really, really on the side of Coinbase the entire time. It was pretty obvious. And I was surprised that even when the judge was listening to the SEC's arguments, the judge really wasn't diving into the common enterprise or to be derived from the efforts of others part. There were a lot of questions about other things. Very, very brief touches on, rescission and the potential to sue. We talked about Bitcoin not being a security, how the judge said, why? Because it's potentially a replacement for fiat, or more like a commodity. And then, of course, we had the Beanie Baby argument. So the Beanie Baby argument was very interesting. The Beanie Baby argument was this idea of, hey, well, if you call tokens a security, then Beanie Babies might be a security, or baseball cards might be a security, or the judge even said this, fantasy football teams might be a security. So basically anything you put your money into and speculate becomes a security if you say that tokens are a security. And the judge here seems to be siding with the idea that maybe crypto's just its own thing. Maybe we need the Crypto Enforcement Commission, right? As opposed to the I guess it's Securities and Exchange Commission. But anyway, you get it, okay? So like, whatever, some other organization to regulate this new sort of thing. Like maybe there's a collectibles organization, like there are rating companies for rating cards, and there's a commodities commission, there's a securities commission, maybe we need a crypto commission, right? And it needs to be something totally separate. And so the judge is really worried about giving Coinbase too much power here. So if I do... again, we have a summary of issues so far on ehack.com, but I'm going to put an additional summary of issues for the SEC so far. And I would say that these are some of the new items that came up just while we're finishing up the break here. We'll go through some of these. Additional issues for the SEC would be the overbroad risk of calling everything a security.
All right, so part of the summary video that I'm going to make afterwards here is that this is a court case that SEC alleged that these 12 here are securities. These 12 crypto tokens are securities, which are Solana, ADA, Matic, File, and the rest. And Coinbase has argued that SEC is overstepped in classifying these things as securities. And since they allowed Coinbase to be publicly listed in 2021, they sort of greenlit all of this. So they're being contradictory to themselves. Also, a couple of times the Coinbase lawyers have argued that SEC asked Congress for permission to regulate crypto and they were never given. So they just took it through enforcement action, which is kind of a logical conclusion. Now, Blockworks here says that it's a rare occurrence to dismiss this early in a case. So let's not expect them to dismiss this today and right away. I think the judge will hear them out and think about it. Now, this isn't the judge's first case. In August, she dismissed a class action against Uniswap, noting that in her opinion, that Ether is a crypto commodity. And she noted that Congress and the courts have yet to make a definitive ruling whether or not classify cryptocurrencies as securities or commodities. So it's not her first rodeo when it comes to crypto. Based on judges' prior dismissal of Uniswap case, it's clear, her clear understanding of technology, her finding Ether a commodity, acknowledging that Congress needs to be involved here. These are all positive things for Coinbase. So we're about to hear summary arguments. Let's jump back into that. Let's see if they are back yet.
Of wallet addresses. Okay, but are wallet addresses people who get rights? You see what I'm saying? So let's like, it's complicated, but it's kind of an interesting idea because it's like, yeah, I mean, if I hold a stock, or a share of a company, I'm a shareholder of record. There's a transfer agent that documents my ownership in the company, and that ownership gives me the right to sue, to vote in elections, potentially if you have voting rights, to receive dividends, to receive assets in liquidation, right? That's another one. No, they're not back yet. You are right, it's 32, but they're not back yet. So I will just write, they'll be back shortly. Do tokens give rights in liquidation like shareholders of record? No. All right, that's actually a really good counter argument to the argument that I made about the SEC. I feel like I'm debating myself.
I like Kevin here. He's making good arguments for both helping SEC and Coinbase. I don't think he should be helping the SEC, however, since we don't need to help them. Good point that he made here was when you own tokens, you don't have any rights to the company, and there is no company. These are decentralized protocols. Now, when you own shares in a company, you are entitled. You are the legal partial owner of that company. You're entitled to sue them. You're entitled to vote on who the management is. You're entitled to vote on compensation of those people, on dividends, and in case the company goes bankrupt, you are entitled to liquidation of those assets. None of those things are true when it comes to crypto. So this is how the things different, and I don't know if they need to make these cases or these arguments, but hopefully the judge already has heard this in the Uniswap case and seems to be leaning towards Coinbase. Now, again, we don't expect a resolution today, but just hearing the arguments and judges' questions so far has been very positive, and we still have time to buy more Coinbase. All right, let's see if they're back.
What is eHack? Just go to ehack.com and figure it out. It's just where I put my research.
All right, they're not back yet. So, a couple of notes that I took is the Coinbase, as far as validating, this is huge for Ethereum, because Ethereum is not just for Ethereum, but it's huge for Coinbase, because Ethereum contributes to, I'll say, about $400 million of revenue to Coinbase from staking rewards annually. So if the SEC was to say staking is illegal or somehow violating laws, they would use a huge chunk of their revenue, which would not be good. Second, by further clarifying that staking is not part of the securities, then Ethereum has more of a green light from the regulator. All right, let's jump back into it.
Something that I think is critical to the court's decision today. There's been a lot of talk about Ripple, Terraform, and Library, and I know the court's going to look at the cases and the briefs. So, in one respect, we absolutely agree with the court that this case is different, and the reason it's different is because in this case, we sued the intermediary. So the cause of action was, here's Section 5 under the 34 Act. In those cases, all of them involved, at a minimum, causes of action under Section 5 of the 33 Act. But what those cases did involve, and I think there's been a perhaps accidental misstatement, particularly of Terraform, is sales by those issuers on these, what we're calling today secondary market platforms. And to read from Judge Rakoff's summary judgment ruling, and that's page 16, I think, of the Westlaw version at least, and it's in a section where he says that Terraform violated Section 5. Terraform also sold both Luna and MIR tokens to secondary market purchasers on ... crypto trading exchanges. So our contention is, if he's correct that those were securities, and these crypto trading exchanges meet the statutory definition of exchanges, those exchanges are violating, like Coinbase, Section 5 of the 34 Act, while Terraform is violating Section 5 of the 33 Act. Neither Ripple nor Terraform nor Library involved any claim by the Commission that a sale between, what I'll say, two of us here at this table was a violation of the Act. All of those cases focused entirely on the issuer's conduct, but all of those cases, Ripple included and Library, all of them, they sold also on these platforms, right? And Judge Barbaduro found no meaningful distinction, neither did Judge Rakoff and Terraform find any meaningful distinction between an issuer selling on the platform and in what Judge Torres calls blind bid-ask transactions, or selling them more or less directly through these, one-on-one meetings. And the reason that matters to us, Your Honor, is because, the cases are different in the cause of action. Our perspective is they're identical in terms of the Howey test that applies. And we think Coinbase is trying to create a different Howey test for when the people at this table might sell the tokens to each other on its platform, and when Terraform might sell its tokens on Coinbase's platform. And we think that's just wrong, Your Honor. And actually, Coinbase did the court a favor, put some of our briefs there. And if the court does, in its spare time, look at the briefs, our briefs and the defendant's briefs, they're actually remarkably quite similar. A lot of them talk about these contractual obligations. And so our perspective is it's the same test. The fact that it's an issuer selling it on the platform, or that two people are reselling it amongst themselves, does not materially alter the outcome. And why does this even matter for this case is that there was a lot of conversation about the asset hub, but the key sentence in paragraph 65 of our complaint, Your Honor, is actually the last one, which Coinbase, I believe, admits, or at least qualifies. And what we say there is that Coinbase does not restrict issuers from selling its tokens on these platforms. And they admit that Coinbase permits them, subject to certain restrictions, to create customer accounts and engage in secondary transactions. So if Judge Rakoff is correct, then that's the end of this motion to dismiss, given that admission in paragraph 65. Now, to be fair, to be clear, We focused it on sort of the Solana and these tokens because, again, we don't view a distinction between the issuer selling, or what Coinbase calls engaging in secondary market transactions on the Coinbase platform. That's a reference to the exchange, not Asset Hub. And again, people at this table selling amongst themselves. So that's the clarifying point. I'll now move into a brief summation of the court's indulgence. So the parties agree,
Very weak.
I think,
Very
Your
weak.
Honor, that this case is resolved by the statute, and really it's not a major questions case. There's some modicum of agreement. Where we part ways with Coinbase, at least for purposes of this summation, is as to what Howey requires. We think they're making up a new test, and we believe that our position is the one that's most faithful and consistent, but in fact compelled by the Howey test. It's not just a plausible reading as they claim it is. And one phrase I would like to leave the court with that was not discussed a lot today, that I would like to have in the court's mind before we leave, is economic reality. Economic reality is part of the analysis that Mr. Costello was offering earlier, and that I believe is completely devoid from Coinbase's arguments, and that provides part of the limiting principle, including the court's concern about a floodgate of private actions. And so I'd like to borrow from a rhetorical question that the Chief Justice asked in the Biden versus Nebraska case. Would the Congress that enacted this regulatory structure be surprised that the Commission is bringing this action? We know they created the Commission. We know they said to securities exchanges, you've got to register. We know they gave the Commission the power to sue if someone violated this command. So the answer to whether they would be surprised, and Coinbase, we know, does not dispute for purposes of this motion that they are an exchange. The answer to the question depends on what are they exchanging? Coinbase and the amici suggest that we're suing the supermarket, that we've sued Whole Foods. And I concede that if we have sued Whole Foods, we should lose. But economic reality makes it quite plain that our lawsuit and these transactions and these assets are of a quite different nature than if I were suing someone for intermediary transactions in bananas or other items that they've used in their examples. What is at issue here, and let's just imagine this in the eyes of the Congress of 1934, it's an exchange. That's conceded for purposes of this motion. The exchange permits buyers and sellers, they get together, and they trade in these assets. What are these assets as a matter of economic reality? There are issuers also in this marketplace, and these issuers are saying, and in 1934 there's no crypto, so what they have maybe is just a piece of paper with numbers to keep track. That's all that is, and that doesn't do anything. It represents what these investors are buying. And the issuers say, give us all your capital. Give us your capital. We're going to take this capital, and with this capital, we're going to make these little pieces of papers with numbers valuable. And you'll be able to resell them, and you'll make some money. And the exchange, again, the conceded exchange, also permits people to buy and sell amongst themselves these same little pieces of paper. And everybody knows, because these issuers in 1934 have flooded all the then available methods of communication. And they bought radio ads, they put it in the paper, and they sent glossy mailers, and they said, this is what we're going to do. Because I have to explain to you what these little pieces of paper do. They're not bananas. Let me explain to you what's going to happen with them after I take your funds and deploy those funds into this ecosystem. You're going to make some money. And the other thing the issuers remind everyone of consistently is, and I'm going to keep a big stash to myself, because when they go up in value, I'm going to make money too. So the reasonable investor in 1934 understands that what they're buying into is an investment contract. Would the Congress of 1934 be surprised that we've asked that this exchange register? I submit to the court that the answer is plainly no.
I think him referencing 1934 in 2024 is a huge mistake. This is a new thing. This is crypto. It's archaic to reference a law from 100 years ago. It's archaic to reference a law from 100 years ago of 1934 in case of crypto. I think he's making a huge mistake.
Would not only be surprised, but actually stunned that there would be such an easy workaround to the carefully constructed regulatory structure that they created.
in 1933 and 1934 around the capital markets. So we are asking that the court not endorse such an outcome, Your Honor. We are simply asking that the court look at the economic reality, apply the Howey test as it was written, and to end on a major questions point, we believe that the Howey test is there precisely, as I said, to give effect to that congressional purpose and to set it aside or add elements to it as Coinbase is really asking the court to do is what really would create violence to the statutory structure. For those reasons, Your Honor, we ask that Coinbase's motion be denied in its entirety. Thank you.
Thank you very much. Just one moment, please.
Kind of really dodged the idea about an investment contract being missing. He suggested, like, oh, well, they tried to write around it or whatever. That's not the strongest argument.
Thank you. Someone at the back table.
Your Honor, good afternoon, and I think I've been designated to...
Congratulations.
Thank you so much, and let me say that we're grateful for all the court's time and patience with our arguments.
Not at all. Thank you. No, you've helped me more than I've helped you in any way, but thank you.
Thank you, Your Honor. And let me start here. I think after all of it, after our 4.5 hours, and after hearing from our friends at the table in front, the SEC still has not alleged and doesn't contest, doesn't argue that the issuer of any of the 12 tokens that it challenges in this complaint made any statement that could be interpreted as a contractual obligation, still less any kind of promise or obligation that traveled with any of the 12 tokens at issue when they were sold in blind transactions on the secondary market. We heard a little more about paragraph 65 of the complaint, and I don't want there to be any confusion on that. That paragraph allows that promoters, like everyone else, can make trades on the platform of tokens that have already been issued. It does not involve primary transactions. It is purely secondary transactions. That's what paragraph 65's last sentence is about. And for the reasons we've talked about, nothing in the allegation of this complaint gives rise to any allegation regarding any primary transaction or initial coin offering. And the fact that there are no promises of any kind that travel in any of these transactions, we think is fatal to the complaint. I want to talk just a bit more about Howey, because it's an important case. And I don't know if it's the alpha and the omega. I don't know if it's the beginning and the end, but I don't think there's any mistake about it. Howey is where we start. And the promoter there, just talking about economic reality, the promoter there was a company. It sold parcels of land and a commitment to do stuff on that land, 2 contracts. The question before the court was whether those 2 contracts can be stapled together. If the answer was yes, there would be an investment contract. If the answer was no, there wouldn't be. An asset plus an obligation. That is what all the blue sky law said an investment contract was. That's what Howey said it was. Now, the commission has argued in its papers, and we didn't get a chance to talk about this when we were talking earlier, that Howey's obligation to develop the orange business was what it called purely incidental. It does this, the commission does, by plucking those words purely incidental, rather obviously out of context in Howey itself. The sale of the land, the asset sale, was what the court called purely incidental. The management contract, the contractual obligation to develop the business, that was the opposite of incidental. It's what made the arrangement a security. There's no way to read that opinion and not understand it. You can even read Justice Frankfurter's very short and completely overlooked dissent, and it'll tell you the same thing. There is no doubt that what made the 2 contracts there, an investment contract, was that the asset was stapled to an obligation to manage. The cases, one after another, teach the same lesson. I won't rehearse them all. I will also refrain from undue counterfactual historiography as to the question of what the congressmen and women of 1933 and 34 would have thought about this, but I'll tell you this. I think there would have been a lot of surprise to find that an investment contract didn't have anything to do with a contract at all. And that is the position that's being sponsored here, that the very words of that statute are being erased from it, completely in derogation with all the case law that preceded it, and all that has followed. I'll also say I think it would come as a surprise to Senator Loomis that this was obviously something that was to be regulated. I won't cause the court to look at it, but slide 12 recounts about, I don't know, maybe a dozen and a half statutory initiatives over the past 2 years where Congress is trying to figure out who crypto should be regulated by and how. I think there's an awful lot of surprise, historical and present, about the willy-nilly arrogation of regulatory authority that the SEC purports to assert by virtue of this action. Part of the trouble with the position the Commission here sponsors is that we wish to insist that there has been no showing of a necessary limiting principle. We talked about this a little bit, Your Honor. I want to push on it because it won't do to say an asset plus promotional statements is enough. And it won't solve that problem to say, well, you're buying into an ecosystem. I am advised that there is an Apple Plus documentary about Beanie Babies that talks at great length about the...
Please don't make me watch it.
Your Honor, I thought about it. That makes perfectly clear the communities that grew up around that. And it's true of all sorts of things that people buy and sell. The buying into a community. It is an absolutely vacant limiting principle. It's no limiting principle at all. The point is further illustrated by the acknowledgement, the concession that Bitcoin is a commodity, not a security. Bitcoin has every bit the ecosystem of these other tokens. There are community groups, there are chat groups, there are validators, there are support groups. Bitcoin is an ecosystem just like all of the others. And that won't do as a limiting principle as the Commission's own actions, we think, make clear. On the other branch of our argument...
So they just argued that since Commission, SEC has ruled a Bitcoin is a commodity and not a security, all of these things are like Bitcoin, and therefore they will be inconsistent with themselves.
Enterprise, idly. That's from the Supreme Court, 328 U.S. at 299. That's Howie. And it's not for nothing that Judge Boudin talked about in finding and discussing investment contracts that what was purchased in this case was not a share of a business enterprise, and so not a security. These cases haven't addressed this issue, because this issue is new, but they address the principle at issue here, which is when does an investment in an asset become an investment in an enterprise? And the answer is clear in case after case. It is at the moment where the asset is stapled to a contractual undertaking that gives an interest in the enterprise. Let me close with just a word or two more on secondary markets, because I think the following can be fairly said. The Commission's complaint draws the court into truly unprecedented territory. To call these secondary market transactions investment contracts when there's no contract is atextual, historical, and it's unprecedented. There has been no finding of any kind, any court, that a transaction on the secondary market gives rise to an investment contract, and that is not a coincidence. Echoing the conversation, Your Honor, that you and I had a little bit ago, investment contracts, well, they're contracts after all, and that implies privity. And absent unusual circumstances that haven't eventuated in the decided cases, circumstances that one could imagine, but nevertheless aren't alleged here, contractual obligations could travel so as to create an investment contract. No allegation here. And what we say you can't have, what we say would make a hash of the statute, is an investment contract without at least the appearance of an offering. And that is completely not alleged in this case. And there was reference...
May I hear that again, please? You cannot have an investment contract without at least the appearance of an offering?
You can't have an investment contract without at least the appearance of an offering of an instrument that carries with it the contractual obligation.
Thank you.
Just while we're talking,
what do you mean by appearance of? At least the appearance of? it's this strange simulacrum that you're suggesting. I want to know I guess you're just trying to cover all bases. I just want to know what that means. It's the word appearance that's thrown out.
And it's fair enough. And what we're trying to convey here, Your Honor, is an attitude towards this instrument that is not ungenerous, but generous towards the Commission. If there is an instrument that is meant to convey a contractual obligation, that is an offering of an instrument that is meant to convey that will satisfy the securities laws. But it has to partake in the appearance or offering or intent to create a contractual obligation. Otherwise, you do not have an investment contract. You just have an investment. So it's got to be stapled to something that, from an objective standard, could constitute the offering of a contract in the mind of a reasonable offer and offering. I wanted to very quickly just mention the Dow report because it came up earlier and it bears a little bit on this because it's the kind of instrument that one can imagine fulfilling some of the characteristics that aren't fulfilled in the pleadings. But what I wouldn't want left is the impression that the Dow report put anyone on notice of what was going on here. Here's what the Dow report said. The Dow token was like, and I'm quoting now, buying shares from the SEC. The token was like buying shares in a company and getting dividends because token holders could vote to distribute the Dow's anticipated earnings from the projects it funded. That was the Commission's conception in 2017. Notice its language. It has all the earmarks, not just of what we're saying today. And of course, we're litigants, so you'll be skeptical of us. We have a position. It has all the hallmarks of all the cases I've been saying for 100 years. 2017, you had an instrument that was buying shares, that had the possibility of getting dividends, that had voting rights, and therefore had an interest in the enterprise in a manner that at least resembled other securities. That's what the Dow report was about. And we're 180 degrees away from that point now. In fact, no court has ever held that something without those sorts of attributes can be traded on a secondary platform and be a security. Finally, I want to say this, and then I'll stop. Coinbase appreciates the utility and the wisdom of sound and predictable regulation in the crypto industry as in elsewhere. The court should know that Coinbase is subject to many regulatory regimes, state regulatory regimes, the CFTC. It's not as though there is no regulator with any authority beyond the SEC. And Coinbase has made clear in this case, in its public statements about the SEC, that it's looking for rules of the road. And we know the SEC has a broad mandate to regulate things that are securities. But the SEC's regulatory reach does not go beyond securities. And if it's permitted to regulate here, it's permitted to regulate everywhere. And it could do so in after-the-fact enforcement actions, with or without notice, with or without warning. And that is not the way administrative law is supposed to work. The SEC knows, Your Honor, that it's trying to squeeze crypto transactions into a statutory rubric that they don't belong. That's the significance of the Chair Gensler remarks. That's the significance of the Hinman report. That's the significance of Dow. There's an understanding that they don't fit. We know Congress is trying to sort it out. And what should happen here is the SEC should follow enforcement and rulemaking actions that make sense of the statutory language, that does not twist it upside down, that does not read the word contract out of the word contract, that harmonizes rather than does violence to all of the cases that have come before it. And this is several bridges too far. And for that reason, we really urge the court to grant the motion.
Wow. Strong.
Earlier today, my deputy said to me with some horror, "Are you going to decide this from the bench?" And then it only prompted horror on my part because no, I was clearly not. I had questions when I began this day. I have some answers, and I have some questions as I end the day. So I suppose I should thank you both, and it is a measure of everyone's preparation that I can't decide this from the bench right now. So take that as the compliment it is. I have a favor to ask of the folks at the back table, and that is if you would please, if you would accept a friendly amendment of your transcript order to be tomorrow rather than this evening, because I'm aware that the court reporters have been moved to other places this afternoon, and I kept them so much longer than they thought, that I just ask for your indulgence. Again, since I'm not deciding today, and with appropriate respect to your client, tomorrow should be fine for everybody, so I'm going to ask that your request.
All right, we're going to do a summary. Let's do a full summary on this. I'll give you the decision. The case is over. It's not going to be decided now, so we can disconnect on this. Let's do a full summary. So if you've got like 8 minutes, let's go ahead and let's just go through everything. So if you're just now catching up, I'm going to record this. I'm going to post this on the main channel, okay? I look like crap because I've been sitting here for 4 freaking hours. Dude. Whatever. Okay, let's go through this is a lot, okay? So I'm gonna do my best, and I'm gonna give you my opinion as to who won this case. Should be obvious already, but I'm gonna give a full and neutral and unbiased summary. So here we go.
Coinbase won.
Lower this a little bit because it's annoying. There we go. All right, make sure that's rolling. Yep. All right, we're good. There we go. Wow, I went into the SEC versus Coinbase lawsuit hearing today, January 17th, 2024, honestly expecting that the SEC would come prepared with an incredible argument for why the 12 tokens that they listed were a security. And Coinbase, I thought, was going to have a hard time defending against that. In this video, I'm going to give you my opinion in terms of who won this case. Right now, the motion at hand, the decision at hand for the judge, is whether or not to let the case continue or to dismiss the case, to decide the case based on the pleadings thus far, or to throw the case out. The judge has indicated she is going to wait to make a decision, and she is not going to rule at the moment. So, without the judge ruling at the moment, we are going to go through some of the summaries and some of the big cases here.
Okay, we're not going to go through the summaries right now. I am going to make a full video later detailing prior cases like Uniswap that this judge ruled on, and a full summary of what happened today. I did miss the first hour myself, so I'll have to go read the transcript and then fill you guys in. Video should be out later today or tomorrow. Still feels really good for Coinbase. I am holding strong. In fact, buying more Coinbase today if it's not too late. Thank you for tuning in. Please subscribe, like, and hit the bell icon to get the notification for the summary video and the rest of our news on Coinbase and crypto markets. Until next time, peace.